Hello, everyone. My name is Sophia Martin, and I am the Integration Housing Officer on the housing team at Church World Service. I'm joined by my colleague, Lynette Pearl, who's the Senior Associate of Housing at Refugee Housing Solutions. And we're here today on behalf of Church World Service and Refugee Housing Solutions to talk about lead abatement. So Refugee Housing Solutions, for those who aren't familiar, is a project of Church World Service funded by the U.S. Department of State to serve all 10 national resettlement agencies to pursue access to safe, dignified, and affordable housing for all newcomers. RHS pursues this goal in a number of ways, including through resource creation, trainings, and individualized technical assistance sessions with subject matter experts. So here are the learning objectives for today's training. By the end of today's session, everyone should know when to have your home inspected for lead risks and know what the inspection should include. Know the U.S. federal rules and regulations on lead exposure, and be well-versed in tenants' rights regarding lead. So I'd like to begin with a bit of background on lead. Lead is a chemical element that is poisonous to humans. Humans most commonly come into contact with this toxin because paint for homes' walls, floors, interiors, and exteriors were almost exclusively lead-based prior to 1978, until when lead-based paint was legal for residential use. So now let's go over some symptoms and signs of lead poisoning in both children and adults. A quick disclaimer before we jump into this section: the following symptoms in both adults and children may also be warnings of other conditions. Neither Lynette nor I are healthcare providers, so if you do live in an old home with painted walls and floors, and you or your child or your client or their child is experiencing any of these symptoms, lead poisoning may be the cause, and it would definitely be worth consulting your healthcare provider. That said, the following symptoms are associated with lead poisoning in adults. So high blood pressure, joint and muscle pain, headaches, abdominal pain, difficulties with memory or concentration, mood disorders, miscarriage, premature birth or stillbirth, reduced sperm count in men. Though lead is never safe for humans, it's always toxic. Lead poses significant threats to children's developing brains and bodies, especially if they're under the age of 6. The symptoms can include slow growth and physical development, including motor skills, damage to the brain and nervous system, lower IQ, hearing and speech problems, learning and behavior problems, which can all manifest in decreased ability to pay attention and an underperformance in school. So where can we be exposed to lead? We're talking mostly about housing today, as that's the most common lead exposure source. But there are also some other areas that folks can be exposed to lead, so we want to highlight those as well. But any residential building built before 1978 likely contained lead-based paint at one point. Many of these buildings have been updated since then, and the lead dangers mitigated. That being said, in homes with unchanged paint, when paint peels or cracks, it can create lead dust that is dangerous, especially to children when inhaled or swallowed. It's worth noting that some older water pipes may also contain lead, and other than pipes in buildings, some toys and jewelry contain lead. So it's worth being cautious of older painted toys, specifically around children. Regarding refugees and newcomers, we're thinking mostly about toys or jewelry that have been donated. So folks should just be aware of any of those painted toys. Another cause of lead exposure is aviation gas used in piston engine aircrafts. This cause is really only relevant to folks who live near airports, as lead from these emissions can contaminate soil or water sources near the airports. So when should you have your home tested for lead? If you live in a home built before 1978 that has not had lead mitigation work done, especially where children will be living or visiting, you should definitely have your home tested for lead. Beyond that, if you're planning to repaint or remodel your apartment or house, it's important to have your home tested, as remodeling or repainting can expose paint that's been covered up and mitigated in the past and create those chips or super dangerous lead dust, especially if you have children around. You should also have your home tested for lead if you're renting or buying a new house, or if you are concerned about lead exposure to you, your family, or your visitors. So if somebody you know, or somebody in your family, or one of your clients tests positive for lead in their blood, it's definitely a good idea to have your home tested. So what do you do if your home does test high for lead? The first step is to contact the landlord or property manager immediately to arrange for lead inspection and, if necessary, abatement. Lynette will talk a little bit more about how exactly to go about this and some of the federal rules and regulations that you have a right to if something like this does end up happening. Next, occupants should also be moved to temporary living situations immediately, particularly if there are children under the age of 6 in the household. And finally, everybody in the family, everybody living or visiting the house should schedule doctor's appointments to be tested for lead and then receive proper care and treatment from there. That concludes my portion of the presentation. I'm going to hand it over to my colleague Lynette to talk a little bit more about federal rules and regulations.
Thank you, Zoe, for that intro and for that helpful information. Um, we're going to talk about lead-based disclosure rule. The disclosure program aims to prevent lead exposure in children, families, and women of childbearing age. Now, the lead-based paint disclosure rule requires that potential buyers and renters of housing built before 1978 receive certain information about lead and lead hazards in the residency before buying or renting. So, what does Section 1018 of Title 10 cover? Well, this rule applies to all housing defined as target housing, which includes most private housing, public housing, housing received federal assistance, and federally owned housing built before 1978. Now, later in this webinar, I will go over which housing stock is excluded from this rule. Before having a client sign a lease or you sign it on your organization's behalf, research the property and or home to see when it was built, especially if you are housing a family with small children and an expecting mom. Now, when you know the year of the building, you can be better prepared for the tour. During the tour, you should actively look for peeling, chipping, or deteriorating paint in the unit or home. Now, if you are placing an expecting mom or a family with children in a unit or home built before 1978, advise them to be proactive about their cleaning habits and getting their children's blood level test regularly, as my colleague Zoe stated earlier. Your goal is to observe during this inspection any paint surface that has been disturbed. Now, during a lease signing, or if you're helping a client renew the lease, the housing provider and landlord, they must include lead-based hazard information in their lease and rental agreements. Now, they may also include information regarding common areas and other units of the property, especially if it's a multi-unit building. Now, I want to point out that even if a lease is oral or informal, the landlord is required to do lead notifications. Now, when an applicant is signing a lease or when a tenant is doing a renewal, the landlord must provide them with either EPA pamphlet or a state approved version of the pamphlet. Now, once the landlord provides the applicant and the tenant with the EPA disclosure form, both parties are required to sign it to meet the notification criteria. Now, here is a snapshot of the lead-based paint disclosure. FYI, if the applicant or tenant does not speak English or English is their second language and they're having problems understanding this actual disclosure, um, the landlord is required to provide this disclosure in their language. So this is a very serious thing because the last thing you want to happen is have a client sign off on this disclosure. They really truly don't understand it. And then there's some issues with the unit or home, lead-based issues, and they sign this disclosure. This gives the landlord some leverage. So it's very important that they understand what this disclosure means. Um, when it comes to legally waiving rights or being notified appropriately about any lead issues. Now, I talked about what is expected of a landlord and what they should provide before the lease signing, but what is required of them if they plan on doing the renovations during a client rental tenure? When I was a housing specialist, I would have clients being in a rental unit for 3 or 4 months. They call and reach out to me, say, "Hey, Lynette, um, my landlord's now doing renovations, so I'm kind of concerned about lead issues." Well, federal regulations require renovators to give tenants 60 days notification and a copy of the EPA Protect Your Family from Lead in Your Home pamphlet, and that's the snapshot of it right there. And just FYI, this pamphlet is currently available in different languages. So before the renovations of the rental units or common areas in the building, they must give them notification and this pamphlet. Now, the renovator may be the contractor handling the renovations, or it may be the landlord if they're doing the work. Regardless, if the renovations are done by a contractor or a landlord, they must give notifications. Now, if the renovations only affect certain units, only people in those units need to be notified. Now, if the renovations affect common areas, everyone generally needs to be notified as well. I have found if a landlord is a very good landlord, usually they give the information to all who are in that building where the renovations are going to occur. So anyone affected has the right to get a free EPA pamphlet about renovations. Exceptions to this notification rule is if there is an emergency renovation, if it's minor repairs or maintenance and renovations in buildings that have been certified, the key word certified, is not containing lead paint, or renovations to common areas in buildings with 3 or fewer units. Now, this might be slightly different if there's children in those units under the age of 6. Now, if the renovator does not comply with the notification process, they could receive penalties up to $21,000 for each violation. They can also face criminal charges and can be sued by the tenant. That's how serious this notification process is. So at the beginning of the presentation, we discussed which housing is affected by this rule, but we need to go over which housing and under what conditions are exempt. So housing built on or after January 1st, 1978 are considered exempt. You may be asking, well, why this rule applies and it doesn't extend beyond that time period. Well, it doesn't extend beyond January 1st, 1978 because the Consumer Product Safety Commission banned using lead paint in housing in 1978. So that's when it got officially banned. Housing found to be free from lead-based paint by a certified state accredited lead inspector, or an all lead-based paint has been removed and clearance has been achieved and verified. Housing exclusively for elderly or persons with people with disabilities, unless a child under the age of 6 is expected to live in the residency for long time periods of time, not just visiting. However, again, we want to protect our youngins, our little ones. I highly recommend, even if a child under the age of 6 is visiting, make sure the unit is clean, there's no debris, because the little ones like to put things in their mouths and we don't want to put them in jeopardy any kind of way. 0 bedroom dwellings, i.e. efficiencies, are studio apartments. Again, unless a child younger than 6 is living, they are going to be staying there that long term in the unit. And single rooms rented in a residential dwelling. And here are some additional exemptions. It does not apply to housing providers who offer month-to-month rental agreements with no renewals or extensions. Rental agreement terms less than 100 days with no renewals or extensions. And I want to point that out. Again, no renewals or extensions. Short-term stays, 100 days or less, stay with no renewals or extension. An example of this would be vacation homes and hotels, Airbnbs. FYI, this is very important. Landlords are not required to disclose present or past tenants who've developed lead poisoning. So that's why it's so important when you're in housing to know your craft. When I say know your craft, know not just your federal laws, but know your state and local laws as well. My colleague and I, Sophia, we're just giving an overview of federal. However, depending on your state and also depending on your local laws, there are additional requirements and protections. So that's the reason why you should know not just federal, but your state and local laws as well. And here is just an example of what alligatoring looks like, the first picture. The second picture, we call it chalking. And then the third is sublayers of paint. As you can see, they try to paint over the lead paint and it's shedding. So these are just an example of what to look for. Now, for your information, lead is a health hazard only if it's deteriorating. So what should a client do when they find flaking or paint chips? As my colleague Sophia mentioned earlier, there are steps and precautions a client can take to minimize their exposure. First, they should notify the landlord immediately and request that the chips and flakes be tested for lead. I recommend that the request be made in writing. Now, a letter may not be effective in enforcing the landlord to take action, but guess what? It helps protect your client by establishing the starting point where they can prove that the landlord knew about the lead paint, which helps them to prove negligence later on if needed. And it also starts a paper trail that forces the landlord to disclose all known lead paint violations to future tenants according to EPA regulations. So even if your client has a verbal conversation with that landlord, they should write it down. So you're probably asking, well, that's great. What should be in that letter? So these are some common things that should be in that letter. The how. How did they discover the problem? Like, for example, was it through a blood test? Where in that rental unit they saw the chipping, the peeling, the deteriorating paint. Not just written documentation, but I recommend taking pictures so you have visual documentation. Who is in danger? If they have kids, list their ages. That's very crucial. As we stated earlier, children under the age of 6 are very vulnerable. A reasonable deadline for the landlord to resolve the problem. What they expect. Um, again, a tenant might not be savvy enough to know what to expect. That's why your assistance is highly needed. One thing if you don't even know, the thing that you should expect, all lead paint remediation done by a certified lead paint remediator. That's actually a federal law. So if you mention that, based on federal law, they have to have a certified lead paint remediator do the repairs. It can't just be the maintenance man, okay, unless he's certified. And make sure they keep a copy of the letter for their records. So if the landlord has not tested for the lead, the client or you I do recommend contacting your health department to see if they offer free testing services. Also know your state and again, know your state and local laws. Often state and cities which have stringent lead abatement laws have agencies that can come to the property and inspect it and can order the landlord to address any hazards that the inspection reveals. Now, I know a lot of clients like to use home testing kits, but just be aware they're ineffective. Now, the Consumer Product Safety Commission tested more than 300 to do it yourself kits, and they have found that more than half of them either produce a false negative or did not accurately detect lead. One thing you can do if you have a kind landlord, an understanding landlord, negotiate a tenancy termination. One thing I used to do as a housing specialist, if something came up and I didn't want to end my relationship with that landlord, I would simply ask them, hey, do you have a sister property that's comparable to this unit? And if so, can I transfer my client to that actual sister property? But if that is not the case, or if the landlord is not cooperative, negotiate the tenancy termination. The landlord may ask the tenant to sign a waiver not to sue. Um, I highly recommend a tenant does not do that, your client does not do that, or be pressured to sign it unless you take that documentation to your in-house counsel to review, or to legal aid to let someone review that. Again, because you don't want them to waive their rights and they have issues down the line, and then the landlord's no more financially responsible for the situation. Um, Again, contact a legal aid agency to help assist you and your client to navigate through this issue if the landlord is not cooperating. And you can also report a housing provider to the health department. Um, Again, it depends on your health department. I know in Chicago we have a very active health department. Hard to believe, but we do. So just reach out to health department and see if they can assist you with the matter. And you can also call the National Lead Information Center, and that's the number right there. So, FYI, if landlords know about lead-based paint but do not disclose it to your client, and they do suffer injuries, they can sue the landlord for damages. So that's why it's important that they do not sign that waiver. And I just want to give a caveat regarding this piece. Again, me and Sophia are not health professionals or attorneys. We're just giving you this. This is just for informational purposes. So this concludes Sophia and I's webinar. If you have any questions or any concerns, or you need additional support, feel free to reach out to us. You can email us at lpearl@cwsglobal.org, or my colleague Sophia at somartin@cwsglobal.org, or you can simply book a TA session. Sophia, is there anything else you want to add to this webinar before we conclude?
No, I don't believe so. Thank you so much, Lynette.
Again, thank you for your time, and have a blessed day.